Good morning. For those of you who don't know, my name is Simon Passfield, and I'm the head of the insolvency team at Guildhall Chambers. I'm delighted this morning to introduce the two newest members of our team, who, over the course of the next hour or so, are going to provide a detailed introduction to the fun and exciting world of insolvency law. Firstly, Govinder Chambay, who joined Chambers in 2020, after having had the misfortune of a 12-month pupillage under the supervision of me and Stefan Rommel. He's rapidly built an extensive insolvency practice, focusing on all areas of personal and corporate insolvency law. He's already chalked up his first reported case, an interesting decision of ICC Judge Jones in a matter called Re Hussain, concerning an application for possession and sale of a matrimonial home in circumstances where there'd been a transfer of the beneficial interest to the non-bankrupt spouse at an alleged undervalue. And he's also currently assisting me to co-author a book on contested administration applications, which we're hitting your shelves in the new year. And secondly, Saisha Bacon, who joined Chambers this time last year, having completed a pupillage with Jay Jagazia and Jamie Hannant. She's also building a substantial insolvency practice. She deals with the full range of insolvency applications and petitions, and she's currently assisting me with a particularly complex fraudulent trading claim. Without further ado, I'll hand it over to both of them, who'll steer us this morning through some of the thorny and not so thorny issues that arise in insolvency practice.
Thank you very much for introducing us, Simon, and thank you everyone for attending this morning's webinar. In terms of what's on the menu, what we're going to be focusing on is the difference between administration and liquidation. We're going to be covering routes into liquidation and administration, TUVs, preference claims, 423 claims, wrongful trading, fraudulent trading. We're going to be giving an overview of all of those sorts of areas, as well as breach of duty and misfeasance claims and limitations. So what we're hoping to cover is the points and principles that arise in insolvency litigation. So I want to start with a discussion of the difference between administration and liquidation. The first thing to remember is that liquidation is the end of a company. The purpose of it is to distribute the assets in accordance with the pari passu regime. So it's shutting up shop in every sense of the word. Whereas administration, it isn't necessarily the end. And we know that because when we look at paragraph 3 of Schedule B1, we see that the administrator of a company must perform his functions with the objective of, and it's only necessary for this purpose to look at paragraph A, rescuing the company as a going concern. So we see that inherent within the administration process is the theoretical possibility that a company can be rescued, whereas that is not an option in liquidation. There is, to that I'd attach one caveat, which is that it's possible for a liquidator to apply for an administration order, though to my knowledge there's been no reported case which concern that. So the way I would look at it is that liquidation is the end and administration carries the possibility of a company being rescued. But apart from conceptual differences, there are also some practical ones. So we've got time frame issues. Administration lasts for a year unless it's extended by the court or indeed creditors, whereas liquidation doesn't have a time limit. With administration, a company can continue, in theory, trading, and that might be pursuant to rescuing the company as a going concern, whereas the same isn't possible in liquidation. Another practical difference is that void dispositions, they don't apply in administration. So void dispositions are simply where if a winding up petition is presented as against the company, any disposition, or to put it another way, any payment by the company in the event the court makes a winding up order is void unless it's validated by the court pursuant to obtaining a validation order. but that concept doesn't apply in administration. And of course, a company in administration can move to a CVA, and indeed that might form part of rescuing the company as a going concern, but you can't do that in liquidation. So there are three broadly different types of liquidation, and one of the more common types is compulsory liquidation. And this is simply where an unpaid creditor presents a winding up petition against the company, which alleges that the company is unable to pay its debts. Now that can be shown in three ways. So you can show it by way of a statutory demand that hasn't been satisfied. That tends to be the most common one. Or you can allege that the company is unable to pay its debts pursuant to the cash flow insolvency test. Or you can, and do so in tandem, that the company is balance sheet insolvent. And if the court makes a winding up order, it's the official receiver that becomes the first liquidator, and then a liquidator may then take over pursuant to a Secretary of State appointment. Here we've got members' voluntary liquidation, and the image that I tend to have in mind with this is a company which is solvent and the shareholders have essentially had enough and want to close it down. So what happens here is that they make a declaration of solvency. They then pass a resolution of the company to wind up. Liquidation then tends to commence on the passing of the resolution. And the way it normally works is that the liquidator is appointed on the same date as passing the resolution, and of course may be appointed in a general meeting by an ordinary resolution. We can contrast that with a creditor's voluntary liquidation, and the key difference here is that there is no statement of solvency. So they haven't made that declaration. So those are the types of liquidation. And what we can now look at are the routes into administration. And there are principally three routes. You've got the formal court order route. So this is the in-court process under paragraph 10 of Schedule B1. So what that entails is the making of a formal application, and the persons that can apply for an administration order are contained in paragraph 12 of Schedule B1. So that includes creditors, that includes the company, directors. You've also got the holder of a qualifying floating charge under paragraph 14 of Schedule B1. They can appoint an administrator pursuant to the terms of their security. Or what tends to be the more popular route is by the company or the directors under paragraph 22. So that's the out-of-court process.
Right, thank you, Govinder. So I'm now going to just take us through some of the types of claims that could be made by office holders. I'm first going to look at the company insolvency provisions, which is Section 238 and Section 239 of the Insolvency Act. And Section 238 is for transactions at an undervalue, or TUVs, and Section 239 is for preferences. When do these sections apply? Well, these sections apply when a company either enters into administration or into liquidation. For a TUV, though, this Section 238 will only apply if the company is actually a party to the transaction. What do these provisions do? Well, they allow office holders to challenge transactions or things done by the company. And an office holder will make an application if they think the company has either entered into a TUV or given a preference at the relevant time. I'll come back to what at the relevant time means, because that's quite important. But if the court finds that the conditions are met, which will also be taking us through, then they must make an order, and there is no discretion on that. The purpose of that order will be to restore the position to what it would have been if the company had not entered into the transaction or given the preference. It's also worth noting that Section 246ZD2 allows a liquidator or administrator to assign the rights of action under these sections and the fruits of any such action to a third party, such as litigation funder. So TUVs, what is a TUV? It's in essence what it says on the tin. It's a transaction entered into by the company at an undervalue. So what does that really mean? Well, if the company makes a gift that can be a TUV. If it is a gift that's been made, an outright gift, then there must be some form of dealing between the parties. Or a company might enter into a transaction where the company receives no consideration at all. Or the company might enter into a transaction where there's a significant discrepancy between what was paid by the company and what was paid by the other party. And the wording is a transaction with that person, either person who's receiving or who's entered into the transaction with the company for consideration, the value of which in money or money's worth is significantly less than the value in money or money's worth of the consideration provided by the company. If it's under that second bullet point on the screen there, then the discrepancy must be significant. It's also worth noting that the court will not consider it to be a TUV if it can be shown that the company entered into the transaction in good faith and for the purposes of carrying on business. And also, at the time, there were reasonable grounds for believing that the transaction would benefit the company. So if that can be shown, then no order will be made by the court. What is a preference? So a preference is when a company does anything which has the effect of putting one of its creditors, sureties or guarantors of its debts or other liabilities in a better position in the case of a company going insolvent than if the company had not done that thing. With a preference, there has to be this influence by a desire to produce that better position that person's been put into. But if the person who the office holder says received that preference, and if they're a connected person with the company, then there's a presumption that the company had the requisite influenced by a desire ingredient. So if they're connected with the company, then you don't need to necessarily prove that the company was influenced by the desire to put that person in a better position. So that's what the liquidator or administrator is looking for when looking at TUVs or preferences. The next stage is to consider whether these transactions or preferences given took place at the relevant time. So I think the first thing to consider is whether that person is a connected person with the company or not. If the person is connected with the company, and that doesn't count employees who are solely employees, then the relevant time is the period of 2 years ending with the onset of insolvency. And I'll come back to what the onset of insolvency actually means. If the person is not connected with the company, then that period is a much shorter period of 6 months ending with the onset of insolvency. In either case, whether connected or not, and it's the administration we're looking at, then the relevant time also includes the period between the making of the administration application and the making of the administration order, if it's that type of administration, or with the filing of a notice of intention to appoint with the court under paragraph 14 or 22 of Schedule B1 and the date of that appointment. So that's the relevant time that the administrator or liquidator will be looking at and seeing whether the transactions or the preferences given fall within those periods. It's worth noting that the court will not consider it to be within the relevant time unless the company is at that time unable to pay its debts, or as a result of the transaction or preference, or transaction at an undervalue or preference, becomes unable to pay its debts. And that has the same meaning as in section 123, which I've set out on the slides, but I don't think I need to go through. So what does the onset of insolvency mean? So that's when we're looking at whether they're connected or not connected. It's the ending point for the prescribed relevant period for both section 241A and B, establishing it's an important step in establishing whether you have a claim. If it's by administration order, looking at administration first, then the onset of insolvency is the date of the administration application. If it's administration pursuant to paragraph 14 or 22 of Schedule B1, it's the date on which the notice of intention to appoint is filed. Any other appointment, it's the date on which the appointment takes effect. And if we're looking at liquidation, it's the date of the commencement of the winding up. So that is the company provisions. We've got very similar provisions for bankrupts, but these are set out in section 339 and 340 of the Insolvency Act. Section 339 is TUVs and section 340 is preferences. So again, what do? They allow trustees to make an application if at the relevant time the bankrupt entered into a TUV or gave a preference. Again, there is no discretion for the court. If the conditions are met, they must make the order. And again, the purpose is to restore the position to what it would have been if the bankrupt had not entered into the transaction or given the preference. And these provisions, commonly, I'd say bankrupts who are facing bankruptcy or debtors who are facing bankruptcy will try and get rid of their assets, often to family members, for example. And if that family member is a creditor, then preferring them in some sort of way. And this is when applications may be made by the trustee, and I think it regularly happens when it's to do with family members. So what is a TUV under section 339? It's very similar to the corporate provisions, but slightly different. A gift will still count as a TUV. A transaction where there's been no consideration will also count if there's been a TUV. So, for example, if a bankrupt transfers his 3 properties to his wife and then subsequently goes bankrupt, that would likely be challenged if it's within the relevant period. It might be a transaction where the debtor has entered into a transaction with a person in consideration of marriage or the formation of a civil partnership, or it's the discrepancy provision where there's a discrepancy in the consideration paid by that person, which is significantly less than the value of consideration provided by the bankrupt. So it's quite important to note here that the transaction must have been carried out by the debtor to be a TUV. In terms of a preference, again, it's essentially the same thing, but it's when the debtor or bankrupt does anything that has the effect of putting a person who is a creditor, surety or guarantor of his or her, in a better position than that person would have been in if that thing had not been done, and in the event of that person going, the individual entering bankruptcy. Again, there is this need of this influence by a desire ingredient for the court to find that there was a preference, otherwise no order will be made. The court is interested here in looking at who the preference was given to. If the person was an associate of the debtor, then there's a presumption that that debtor had the requisite desire, or the desire ingredient that I've discussed. That is a rebuttable presumption, but when the court considers that, it will look at it in a subjective way. It's a subjective test. And also, just worth noting that a preference can arise out of a court order. So what's the relevant time? So we've worked out there's some transactions or something's happened between the debtor and another party. We need to work out whether it's within the relevant time. For TUVs, the answer will be that it is within the relevant time if the transaction happened in the 5 years preceding either the bankruptcy application or the presentation of the bankruptcy petition, which made the individual bankrupt. This is a longer period, and I'd say quite a long period of time. So bankrupts or debtors should consider that when they are entering into any transactions with the potential threat of going insolvent. For preferences, it's, again, the court will look at who is receiving that preference, who that other party is. If it is an associate of the bankrupt, then that period is 2 years, ending with the day of the bankruptcy application or presentation of the petition. Or in any other case, so essentially if they're not an associate, then at a time in the period of 6 months, ending with that day. There are some conditions that should be borne in mind. The court will not consider it to be the relevant time unless the debtor was insolvent at that time or became insolvent in consequence of the TUV or preference. However, for TUVs, there is no need to prove this insolvency, or the insolvency element doesn't really arise if the transaction was at a time less than 2 years before the end of the 5-year period, i.e. 2 years before the bankruptcy petition or bankruptcy application is made. Again, the court will consider who the transaction was with. And if the transaction is with an associate of the bankrupt, then there is an automatic presumption of insolvency unless the contrary is shown for transactions at an undervalue. So those are two quite important things to consider when considering the relevant time. And it might assist your case or it might not. And I've just set out the meaning of insolvency there again, but I don't intend to go through that. So what sorts of orders can be made? Well, the court has wide-ranging powers, and the thing to remember here is that they're seeking to restore the position to what it would have been if that transaction had not been entered into or the preference not given. And I've set out on the slide the various different orders they can make. So they can vest the property or process of sale in the company or in the trustee in bankruptcy. They can release or discharge any security. They can require payment of sums that the court directs. They can revive surety obligations. They can provide for security to be provided, charged on a property and given the appropriate priority. And they can provide the extent to which the other person can prove in the insolvency. It's the proceeds of any action under these sections will essentially go into the insolvent company's estate or the bankrupt's estate to then be realised for creditors as a whole. As I said, the court's powers are wide-ranging, and there can be orders made against third parties. The wording of the Insolvency Act is that the order may affect the property or impose an obligation on any person. But if the court is being asked to make such an order, then the question will be whether that third party acquired the proprietary interest or received the benefit in good faith and for value. The court will look at the circumstances, consider what that person knew or who that person was. So there will be a presumption that the benefit or interest has been received not in good faith if the third party had notice of the relevant surrounding circumstances or the relevant proceedings. And I'll come on to what notice means in this context. If they were connected with that company or the bankrupt, or they were an associate of the same, or if they were an associate of the other party to the transaction as well. It will be the burden of that third party to prove that they did enter into that or receive that benefit in good faith, and they can't simply shut their eye to the possibility. But it's on them to prove otherwise. Otherwise, the court will presume it was not. So what does notice mean? We're looking at notice of the surrounding circumstances. So if that third party knows that the individual in question entered into a TUV, or if they are aware of the circumstances which amounted to the giving of the preference, then they have notice of the surrounding circumstances. In terms of the relevant proceedings, if that third party knows, in the case of individual insolvency, about the bankruptcy application, the bankruptcy petition, or the fact that any bankruptcy order has been made, then they'll have notice of the relevant proceedings. And if it's for a company insolvency, then if they have notice of the administration application, administration order, notice of intention to appoint, or notice that the administrator has been appointed, then they'll have the requisite notice. And in liquidation, it's the fact that the petition's been presented or the company's in liquidation, essentially. So now Govinder is going to take us through some other office holder claims, starting with wrongful trading.
Thank you, Saisha. So I think the best place to start is let's look at the statutory wording. The court may declare a director liable to contribute towards the assets of a company where it has gone into insolvent liquidation / administration, and at some time before the company was wound up, the director knew or ought to have concluded that there was no reasonable prospect of avoiding insolvent liquidation or insolvent administration. Now, this is an office holder action, and there are two persons that have standing to apply, namely liquidators and administrators. But what are these provisions actually getting at? What are they trying to prevent or achieve? Well, it's neatly encapsulated in that they're trying to prevent directors from continuing to trade whilst their companies are on the slide into insolvency. It's essentially saying that you ought to have ceased trading far sooner, because by continuing trading, all you have done is increase the deficiency to creditors. Now, Section 214 is concerned with losses caused to the company rather than creditors. And because it's an office holder action, it's not property that belongs to the company which is capable of being charged. So any recoveries, they inure for the benefit of unsecured creditors. In terms of the nuts and bolts of one of these sorts of claims, there has to be a date by which a director knows or ought to know that there was no reasonable prospect of avoiding an insolvent liquidation. But you don't have to provide an exact date, although the same is useful, and estimates and alternatives can sort of be provided. And in my experience, that tends to be where you'll refer to one event and there'll be a subsequently very damaging event that occurs to the company, and it's sort of saying that you knew then, but if you didn't, you certainly knew now. In terms of contribution, the amount that a director is declared to be liable to contribute is the amount by which the company's assets have been depleted by the director's conduct, which caused the discretion in Section 214 to actually arise in the first place. And so from a causation perspective, what you need to demonstrate is that there is a link between continuing to trade and there is the increase in the deficiency to creditors. We can contrast that with fraudulent trading. And I've left the statutory wording up there for you to read. It's important to note that administrators have standing in respect of businesses carried on by a company on or after the 1st of October 2015. The elements of this cause of action is that, firstly, the business of the company in liquidation has been carried on with intent to defraud the creditors of the company or for any other fraudulent purpose, that the defendant participated in the carrying on of the business of the company in that manner, and that it did so knowingly, i.e. with knowledge that the transactions it was participating in were intended to defraud the creditors of the company or were in some other way fraudulent. A party to a company's fraudulent trading, it's not limited to insiders, i.e. directors, so outsiders are included as well, and they can often be the counterparty to the transaction. It's necessary with fraudulent trading to plead and establish dishonesty, and there's an important distinction that has to be drawn. It talks about, Section 213 talks about the business being carried on with intent to defraud. It's not concerned with a business which otherwise carries out one action of fraud on one particular customer. And the contribution should reflect the losses caused to the creditors by the fraudulent trading. One of the most useful tools in an office holder's armoury is Section 423, whereby the court can grant relief for what's called transactions defrauding creditors. And the first thing to note is that 423 applies in both insolvency and non-insolvency contexts. Practically, these are claims that need to be brought using the Part 7 procedure. So there are some commercial elements which arise as well in terms of having to stump up a 10 grand court fee. The key advantage to Section 423 is that there is no concept of a relevant time, which Saisha was discussing earlier, as would otherwise apply to Section 238 and 239. So that's one of the key benefits. The reality is that there's a trade-off because one has to establish the avoidance purpose, which I'll come on to in just a moment. But your first stage is to establish a TUV. If you haven't got a TUV, then your 423 case isn't going anywhere. So that's the first stage. What you then have to establish is the avoidance purpose. And the avoidance purpose is set out here at 4233A and B. So in the case of a person entering into such a transaction An order shall only be made if the court is satisfied that it was entered into by him for the purpose of putting assets beyond the reach of a person who is making or may at some time make a claim against him, or of otherwise prejudicing the interests of such a person in relation to the claim which he is making or may make. There are numerous authorities on the avoidance purpose, and this is really one of the most critical points, because it often happens that you can establish a TUV, transaction won't have occurred in the relevant time, so you're not in 238 territory, but you want to use section 423, or indeed the transaction that occurred a long time ago. But where the wheels can sometimes fall off is in establishing this avoidance purpose. And as I say, there are a number of authorities which discuss what you need to establish and what the actual content of the avoidance purpose is. But if we can boil them down to this, the question is whether it was subjectively intended to achieve the avoidance purpose. You don't have to show that it was the dominant or the sole purpose. It's enough to show that it was entered into for that prohibited purpose. What's interesting is that you don't actually have to have any claims against you or any creditors at the time of the transaction. So some of the cases I've referred to here, Midland Bank and Wyatt and Mackay and Douglas, we can sort of describe as some of the older cases where a party's entering into a business venture and they cause a movement of assets in case it all goes wrong. That's still caught by 423. And it's equally important to note that a victim, for the purposes of section 423, doesn't even have to exist or indeed be in the person's contemplation as at the time of entering into the transaction. And that is why it is possible for a trustee in bankruptcy or a liquidator to count as a victim for the purposes of section 423. Now, it's important to note that consequence alone isn't sufficient. We have to draw a distinction between purpose and consequence. It's not enough to show that a transaction had a particular result. It's not enough for you to say, well, if a transaction had a particular result, it must therefore have been intended to bring about that particular result. There is a difference between those two sorts of things. Now, that distinction is quite neatly drawn in the following case, where if we look at the words in bold, to illustrate the distinction using a less homely example than that given by Arden LJ, a commander may order a missile strike on a military target knowing that it will almost certainly cause some civilian casualties. But this does not mean that the missile strike is being carried out for the purpose of causing such casualties. So we come now to breach of duty and misfeasance. Now, these are claims which are typically brought under Section 212. Section 212 is not a cause of action in and of itself. It is simply a procedural mechanism that enables a claim to be brought that would otherwise be brought by the company. It's an application which can be brought by a liquidator, an official receiver, a creditor, or a contributory. And the usual respondents are company directors. So this provision can be used to bring breach of directors' duties claims, unlawful returns of capital, unlawful dividends, negligence claims. And practically speaking, it's normally an Insolvency Act application with either a supporting witness statement or points of claim. So I'm just going to leave section 172 up, and this is typically the director's duty that is called upon. Typically the duty that's called upon. Now, it's often cited as you have to act in the best interests of the company. But if we look at the wording, it's a director of a company must act in the way he considers in good faith would be most likely to promote the success of the company. So it's a subjective test. Did the director honestly believe that their act or omission was in the interests of the company? An objective test will be applied where a material interest has been overlooked, or there's no actual evidence of any consideration being given to the company. And what the court then does is it asks itself whether an intelligent and honest person in the position of the director could have reasonably believed the transaction was for the benefit of the company. We then also have the creditor's interest duty that can apply. So when a director knows or ought to know that an insolvent liquidation is imminent or probable, directors are required to take creditors' interests into account, give them appropriate weight, and balance them against shareholders' interests where they might conflict. Now, Section 1723 is still a good faith duty. The duty remains of acting in good faith in the interests of the company. It's simply that when the duty is triggered, the company's interests are taken to include the interests of creditors as well. So in terms of how to run these claims, it is very, very easy to simply say, well, that was a breach of duty, that was a breach of duty. The question one should be asking themselves is why? Why was that a breach of duty? Why is it wrong? So in terms of case analysis and preparation, the first step is to ask yourself, well, firstly, what was the act or omission? What are we actually complaining about here? What did it involve? What were the steps that led to that act? And why was this act wrong? You then want to stand back and look at when did this act occur? Did it occur during this twilight period where the creditor's interest duty might have been applicable? When we think about loss, we want to think about, well, what were the consequences of that act? What did it mean for the company? Why was it bad in that sense? Again, we can stand further back and look at the wider overall picture and ask ourselves, is this a company that was on the road to insolvency and simply just continuing to trade? Are we in wrongful trading territory? Are we seeing a pattern of a movement of assets in response to creditor pressure? Or is this purely a misappropriation or a misapplication of company assets? These are some of the thought processes that you want to go to so that you can boil down precisely what the act was, why it was problematic, and what the losses were. So Saisha's going to talk us through a worked example.
Right, so we have Mr. X. He is the director of Springfield Co. And Mr. X, on the 3rd of July 2017, causes the company to make two payments, which total £300,000 from the company's bank account into his own personal bank account. 5 years later, Springfield is wound up pursuant to a petition presented by HMRC. So we look at the first step. What is the act or omission? Well, the act is Mr. X paying himself personally £300,000. Why is this wrong? Well, it doesn't appear that that payment from the company to Mr. X benefited the company at all. It cannot be said that it's in the best interest of the company, nor that it will promote the success of the company. Taking 300k is simply Mr. X misappropriating Springfield's assets. So that's the first point. He's misappropriated the company's assets. We can look at when this occurred, looking back at thinking back to what Govinder just talked us through, and whether the creditor's interest duty is applicable. Well, obviously we haven't got the information with this worked example, but we do know that it was 5 years before the winding up of the company. Depending on the company's financial position at the time, Mr. X may have had a duty to consider Springfield creditors. Say, for example, he made the payments 1 year before the winding up petition was presented. HMRC were already investigating the company. He was well aware of this and also was well aware of potential liabilities that might be owed to HMRC. Well, if that was the case, then it would be argued that Mr. X, knew or ought to have known that insolvency was imminent or probable, and such that he would have had to have considered the creditors at that stage. But looking at the test the court will apply, it will be a subjective test. We would say, or the applicant would say, that Mr. X cannot have honestly believed that paying £300,000 from the company account to his account was in the best interest of the company. There was no benefit to the company at all from that transaction. What are the consequences? This is the loss. We're looking at what loss the company has suffered. Well, we'd say if the breach of duty had not occurred, if that money had not have been paid, then the company would be £300,000, would have £300,000 in their bank account. And so the consequence of all of that is that the applicant would be asking Mr. X to pay equitable compensation to the company of £300,000, unless he can prove that this payment was made for a good reason, really.
One of the interesting points that would come out in a sort of case like this is those authorities which explain that once you've established that the fiduciary has actually received the monies, that fiduciary then becomes subject to an evidential burden to explain why the transaction was proper. Now, it may be that no explanation can be given. That doesn't automatically follow that the payment was made in bad faith. But in a case such as this, I think either way, you'd be saying there's no consideration of the interests of the company, and no reasonable person would have thought that transferring money to yourself would have been in the best interest of the company. We've asked for an explanation. He hasn't given one. And so the overall inference is that these payments were bad. They've caused the company loss, and there ought to be an order for equitable compensation. We've got a separate sort of example here where Mr. Y causes the company to make a distribution in excess of the company's distributable reserves. So what we've got here is an unlawful dividend claim, an unlawful return of capital. And of course, the director who causes a company to make an unlawful dividend causes the company to misapply company property. So it gives rise to a breach of duty claim. We know from cases such as Burned Holding that it's fault-based liability. And one of the more recent case in 2020 is worthy of note because it talks about a director being liable for the excess only. So what I mean by that is that if Mr. Y caused the company to make a dividend in the sum of 150,000, and it transpired that the company could only lawfully make a dividend for 100,000, the extent of Mr. Y's liability would be limited purely to that £50,000. And so unless you've got a case where the excess is sufficiently large enough, or indeed it's a case where the company couldn't make any distribution, the quantum of these claims tends to run a little bit thin.
So in terms of a misfeasance claim, if there has been a misapplication or misappropriation of company property, there can be a personal claim that arises in which is called knowing receipt to restore the misapplied trust property, and a constructive trust arises over the property in favour of the company. In order to establish liability, there are 6 things that need to be considered. Firstly, the property is subject to a trust. Now, trust property can be money or land, for example. Secondly, that the property is transferred to someone, and this can include a third party. I'm going to call him Mr. C. It needs to be established that that transfer was in breach of trust, and that the property or traceable proceeds, so say, for example, Mr. C has been transferred a property, a house, for example, and he's sold that property, well, those traceable proceeds have to be proved to have been received by him or the property itself. It has to be shown that the receipt of the property is for Mr. C's own benefit, and also it has to be shown that Mr. C, when he receives that property, has knowledge that, firstly, the property is trust property. Secondly, it's been transferred in breach of the trust. Or if he's not a bona fide purchaser of a legal estate without notice, then and he retains the property or deals with it inconsistently with the trust after acquiring such knowledge. If those requirements are established, then against Mr. C, for example, then he is a constructive trustee of the trust property concerned. There is no requirement for dishonesty in these types of claims. And what the court's looking at is whether it's unconscionable for the recipient, Mr. C, to retain the benefit of the property that he's received. There's also this is a personal claim, knowing receipt. There's also proprietary claims of tracing and following, but I'm not intending on going into those. It's just to flag them as potential other claims.
Yes, and in terms of property being subject to a trust, that will in essence be the company's property, because directors are being treated, aren't they, as being analogous to trustees over the company's property, and that's how we get to the various different types of limitation provisions applying to them, because they're being treated in the same way.
Yes. So, brief word on limitation. It's something that you need to consider with any type of claim. For TUVs and preference claims, as well as Section 423 claims, the time starts to run from the commencement of insolvency proceedings. So that's the date of the winding up order, the bankruptcy order, or the appointment of the administrator. In terms of the limitation period, these actions are generally viewed as actions on a specialty, such that Section 8(1) of the Limitation Act applies, and that gives us a 12-year limitation period. But if the claims are made and it's a claim only to recover a sum of money, then the 6-year period applies pursuant to Section 9 of the Limitation Act. For wrongful trading or fraudulent trading claims, so Section 213 and 214, again, the time starts to run from the winding up order or the commencement of the administration. And for this, Section 9 applies. So we've got a 6-year time limit to bring these types of claims. Then in terms of directors' duties claims, we've got Section 174, and that's viewed as analogous to a claim in tort under Section 2. So that's a 6-year limitation period, and time will run from the date on which the cause of action accrues. For fiduciary duties are Section 171 to 173 and 175 to 177. These are viewed as analogous to a breach of trust claim, to which Section 21(3) of the Limitation Act applies. That will be a 6-year limitation period, and the time runs from the date of the breach of fiduciary duty, unless the breach of fiduciary duty is a dishonest breach, to which otherwise Section 21(1)(a) of the Limitation Act applies, where you've got no time limit. So you've got a contrast of 6 years, or if it's dishonest, then you've got no time limit. But obviously you've got to prove that dishonesty. So it could be quite risky, I guess. In terms of, or otherwise, Section 21(1)(b) applies, and that, for example, is a director who misappropriates company property for their own benefit. That would be Mr. X, the example that I gave, and with that, no time limit applies there.
It's useful when you're sort of plotting out who you think your potential targets are to have limitation in mind, where a number of the payments are to the directors personally and converted to their own use and for their own benefit. You're going to be in 21(1)(b) territory. The difficulty starts to arise where you've got targets that aren't caused, don't fall within that category, where it's not a conversion to their own use, as it were. So that's always helpful to keep directors' duties to at the front of your mind when weighing up who your targets are and how you might bring your claims against them.
And when.